Our last panel will give us the local perspective. Mr. Michael Sanderson from MACo, Ms. Hilary Ruley from the Baltimore City Assistant City Solicitor's Office, Ms. Heather Price from the Caroline County Attorney's, or a Caroline County Attorney, I'll let you clarify, and then Ms. Margaret Ann Nolan from the Howard County Solicitor's Office. And if we could begin with Mr. Sanderson.
Thank you very much, Mr. Chairman, members of the Joint Committee. I'm Michael Sanderson, Director of the Maryland Association of Counties, and I think a lot of the perspective that we'd share with you is ground that you've already heard covered by both Mr. Snyder's overview and insights and from the state agencies. Big picture, the state sets the laws. I think Maryland has a well-balanced and well-conceived set of laws about what things are public and what things are not. The devil gets into the details. By and large, these rules serve the public and serve the agencies well. My fellow panelists this morning can give you some anecdotes and insight, but to be candid, we're basically in the weeds. When we get into the tricky stories, it's not the routine requests that create the tricky stories. We've basically got those solved, and this group should be pleased that that's an undertone of this conversation today. Before I turn over the microphone to folks who have more to add, I want to give one perspective from our organization, the Maryland Association of Counties. This is a topic bubbling up from within our membership as well. We have a conference coming up later this year in December, and one of the things on the agenda for our winter conference is an organizational meeting of what's probably going to become a standing work group on open government practices within county government. The folks at the front of that room are going to be elected officials from Montgomery County and Kent County. And it tells you something about the breadth of these topics, not just public information, but the universe of what should be on the net, what should be readily available, what should be broadcast to the universe, and so forth. This is a topic that's happening at all levels of government, and that we have our largest and among our very smallest jurisdictions leading that conversation, I think, is a testament to this is happening most everywhere. So with that, let me turn things over to my fellow panelists, all of whom are attorneys in local government, both small and large. I think they can share with you some additional perspective.
Good morning. Hilary Ruley. I'm an assistant city solicitor at Baltimore City. I think the city is a good mix. We sort of have a microcosm of what goes on in the state. We have people supplying water, doing zoning, doing traffic. So I see them all, and it all comes under my purview. And my role as an assistant city solicitor. So I want to leave you time for questions if you want. But you know, what strikes me is the law is written for a copier, not a computer. Most of the work that really gets done that people are interested in are emails, or they're in an electronic database. We're generally familiar with the Microsoft Word world, but honestly, most of the city government runs on computer software purchased by software providers. They're the ones that turn on your traffic lights, regulate your water pressure. And so to get information out of that kind of computer database is very difficult for someone who, you know, I think I have 3 devices in my bag. So I know how to operate, and I understand the expectation that I should be able to look up on the internet and get something. But to figure out how to do that, say, for a speed camera, when your vendor changes, is very difficult, because I only have, as an attorney, the legal rights given to me under the purchasing contract for that software. So it's very difficult to perform the search function that the citizen really expects to have done. And so, you know, I think you have to keep in mind that the sliding fee scale really helps the local governments compensate for the kind of time it takes. Our IT department is very interested in making sure your computer turns on and there aren't any viruses. They're not very well equipped, and nor should they be, in accessing or getting information out of a proprietary software program we purchased for a single function. So that sliding scale really helps us. Secondly, with respect to appeals process, the courts really seem like the right place in my mind, only because you don't want to create an MPIA world in which you create certain standards and then you have a completely different world for e-discovery, which is a burgeoning topic for lawyers. There's an entire realm of e-discovery, and local Judge Grimm, who sits on the federal court in Baltimore City, is incredibly well versed in actually doing exactly what I just described, going into someone's hard drive, picking out information and making it available in a cost-effective way. And so if you set up a system in which you have appellate review of Public Information Act requests that get a different set of standards than you do on the federal level, you'll ultimately have, come to a head somewhere. And as an attorney, I'm versed in both worlds, and I can tell you that, the cost-benefit analysis is really what the federal government's using, and so, it makes sense to keep a MPIA review, although it may seem very similar to, say, an Open Meetings Act issue, is very different because it's document-oriented, and the information in those documents, looking at the privilege, is important for a court to keep consistent, as well as how do we access this burgeoning information that's on electronic devices. Yeah, they're just electrons. They don't take up a lot of space. So they're electrons. They don't take up a lot of space, and therefore the amount of information is just exponentially larger than it's ever been. In the 5 years or more that I've been at the city solicitor's office, we've gone from one person doing it part-time just in the attorney's office to now 3 or 4 attorneys to assist the city simply in answering its daily requests. When a media person asks for all the mayor's emails, that takes an incredible amount of time. And I know that may be sort of larger than maybe some of the smaller counties or municipalities, but in fact, they have the same access to almost unlimited electrons to store their information. So, I mean, it's a really an expansive universe of information people want immediate access to. And I think, an impartial appeals process and a sliding scale fee really help to make it fair and to make it cost effective. Thank you.
Yes, hi, Mr. Chairman and members of the committee. I'm Heather Price. I'm the county attorney for Caroline County, Maryland, and I in so much represent some of the more rural and smaller, if you will, although not geographically, members of the state. And I can talk about this issue ad nauseum, but I will spare you that. I really wanted to bring to your attention an unintended use of the Act that is very problematic for myself, being the only attorney in the county. All PIA requests come to me. I'm quite adept at handling them, quite skillful at ferreting out exactly what information we need to reduce the costs and to get it to the right custodian. So all of that is really not a problem, and we've never really had any issues addressing them. What becomes a problem for a jurisdiction such as mine is, for example, a recent case, and this is frequent. It happens frequently across the state, I'm sure. We have business proprietors, entrepreneurs, you would say, that will use the Public Information Act to request information to build a business. So you have people using Public Information Act requests to get, in this specific example, all the procurement information that we have on everything we've ever listed, everything we've ever sold, everything we've ever put an RFP out for, every document, and they want it in a certain way. Of course, we do the best we can. They go on then to build a searchable database of government procurement information that then they offer back to us as a service. And it was laughingly even suggested to me that this was indeed a public service and fell within the public interest, exception for fees. But this is quite problematic for us as it takes up a great deal of time. The requests are voluminous, and I see it as an unintended use of the Act. And that's really, if you have any other questions for me about some of the other in the trenches stories I can tell you about, from the more than 20 years of practicing law, almost always exclusively as a government attorney at various levels. I can assure you that some of the more complicated ones are these unintended ones and some in litigation, but for the most part we are very adept and well-versed in the law and take the requests very seriously and handle them promptly.
Thank you. Ms. Nolan.
Hi, I'm Margaret Ann Nolan. I'm the county solicitor for Howard County. I'm not going to add too much to what you've already heard because I agree with almost everything I've listen to people say. I was in the Attorney General's office for 20 years in various agencies, and I've been the county solicitor in Howard County for 7 years. And so I think what you've heard is my experience also, which is a very consistent approach to the PIA. I do think that historically the one thing I would say has changed is, again, as you've heard, this availability of information. No one picks up the phone and talks anymore. So that's a boon to the public, right? Because everything you've communicated to your constituents and to your spouses and to others in government, it's there in email. So, for example, I've heard the question a couple times about how many of your documents are digitized. That's not usually the issue. I mean, the majority of the requests, I would say, at the local level, at least for us, have to do with planning and zoning projects, development projects, et cetera. But we do get requests like, especially in an election year for, former employees, we want, and so the account's closed. We don't have a live email account for a former employee. So you get a request that said, we want all the emails to and from this particular employee. Well, we thought, we're Howard County, we're technologically very adept, right? We're going to go to our IT department and ask them. Well, a very quick search showed that we had 24,000 emails with this person's name in them. There was no way to sort between something that named the individual and the to and from. Now, as you've heard before, what you really have to do is work with the individual and try and pare that down. While people may complain, and I'm sure they do, about the amount of time it takes, the fact that attorneys have to be involved, there really is no way to avoid the live human being looking at the document. You've got to look for legislative privilege, because I represent the county council too, obviously, not just the administrative agency. So we've got legislative privilege. We have attorney-client privilege. You have to look in cases where there may be a matter in litigation. You need to know what you're giving up, even if you're giving it all up. So I think really, I would say that historically the thing that's changed is there is so much more information out there. As to the fees, the county sets a fee and a fee resolution with the budget when the budget's adopted every year. So ours is 25 cents. It's almost an anachronism to say you pay, you charge 25 cents for a copy. We don't copy anything anymore. You print it out if you have it. And as I said, since a lot of it is emails, we frequently do not charge, because lots of times when a request comes in, first of all, I don't see a lot of them. They're handled by the public information officer, but it only is when you start to realize this is going to take a lot of time that you might, in fact, start keeping track of your time. And sometimes it's more burdensome to try and spend the time trying to figure out how much you want to charge somebody. So by and large, there are very few situations where we, in fact, do charge. The only thing I'll say about an appeal is we frequently do waive the fees. And I don't have a particular opinion about the appeal process if you're going to set one up, except that sometimes the availability of an appeal process in any circumstance may work against the kind of collaboration and problem solving you want, because that's really what this is about. Frequently, my view is, even though I'm a lawyer and a litigator formerly, if you've gotten to court, there's a failure. And that is not, whether you go to OAH, which is very user-friendly, I think it seems less intimidating maybe to citizens, they're still not lawyers. They're still not the, public officials who are used to governmental function. So if you can encourage education of the custodians as well as the constituents about how PIA requests can be handled and should be handled, you go a long way, and you don't want to set it up so that it makes it so easy to just kick it to the next level. That's my only comment about that.
Thank you very much. Delegate Barve has a question.
There we go. I'm not an attorney, so I actually literally do not know the answer to this. So let's say, for the sake of argument, that a agency of a government state or local, fulfills a PIA request and does not redact information that it should have. Let's say you're in a rush to, for whatever reason, confidential information about a citizen is released in the PIA request. What degree of legal liability would state government have?
Well, I'm sure Mr. Snyder can give a more complete answer
Yeah.
than I can, but of course, if it's the PIA assumes that all information is disclosable unless there's a mandatory non-disclosure or a permissive. So if you're talking about the permissive, the failure to exercise a permissive exemption, which you might have otherwise, for example, legislative privilege, then there's no liability. If you disclose confidential medical, sociological, personnel information, I don't believe that there is a provision directly in the PIA proper, but there is a provision a few sections after that for disclosure of personal information. But I don't know. Again,
Well, I mean, the reason I asked the question,
10624, Mr. Snyder
and
says.
maybe you're not the correct person to ask, but you're an attorney, so.
No. Fair game, right?
The example was given of a request that was made of the address of all the children who had lead poisoning, and even I would know that that's not something that you should disclose.
Right.
But if it had been disclosed, wouldn't that have been could that potentially have been a very large liability to the
Right.
whatever agency of government disclosed it?
Yeah, there's actually, I believe, in 10624, as Mr. Snyder's provided me this site, that's actually a personal fine, isn't it, on the public
Yeah.
official?
And it can be a criminal penalty for someone
Right.
who fails to catch that kind of information. The city's had several requests in the lead paint arena, and we work diligently with our Department of Health and our, housing department to make sure that kind of information doesn't go out. The delay can be very frustrating. We actually also had a commercial requester seeking information like that under the theory that, people who don't have computers or something and live in the inner city, they really want just a one-stop shop, and they want to have somebody help them with all sorts of things. And so this vendor came in with the idea that they would sort of get from the city everyone's financial information, their W-2s, how much they make, and sort of give to this citizen a package so that it would make them easier for them to apply for benefits. They didn't have to keep looking for the same paperwork. Well, obviously, there were many problems with that, and from the government's perspective, we want to protect the privacy of the citizens for not only their health information or their lead paint information, but their financial information as well as their private tax information. The MPIA piggybacks on state tax law and prevents us from giving out information that would be on somebody's tax return. So, there is a lot of legwork that goes in from the attorney's perspective, and I can tell you from the city at least, we don't charge for attorney time. I mean, I know that some counties have to go out and pay for that. That's not the kind of time or search or function that we're trying to recoup the cost for.
Well,
So
when we
the bottom line here is that even if the document is readily available and digitized, still you need a pair of eyeballs looking
Right.
at the document to
Absolutely.
make
Right.
sure.
Yes.
I just don't see a way around that.
Okay. All right. Thank you.
Yes, Delegate Knapp.
Quick question for Barve and Nolan.
Yes.
Did you say that there was a request for email messages of a retired employee, and there were 2,400 or
27. Well, the emails or electronic communications in which the person's name appeared numbered something like 24,000, but we could
How
not.
did you deal with it then?
Well, they're still working with that individual, I believe, to try and pare it down to say, what is it you actually want?
And so who then? So it'll be up to your staff to go through and.
Well,
when you determine what this person wants, then your staff's going to have to go through all.
Yes, in
Oh,
that
my
case, we would
gosh.
make an estimate, even if it's 10,000, we would make an estimate, or 5,000. We would make an estimate of the time, and we would charge. And when the few times we do charge the attorney's time as well.
So this could be very expensive.
It could be expensive.
Yeah.
Okay. Thank you.
Mr. Chairman, if I could add one more item as
Please.
you deliberate on this very important topic. Keep in mind from my fellow attorneys in some of the rural jurisdictions that we're not really we're less affluent in some instances and don't have the type of software and technological availability and things that some of the other jurisdictions that you do have. So you're really dealing with a very wide problem and trying to narrow down, how the documents are accessible. We are moving towards scanning and saving, but that requires the creation of templates and et cetera. So.
Thank you very much. And I want to make a note that, especially for members of the committee, we are very, very mindful of this issue of the difference between the state agency and locals and municipalities who have very different contexts in which they're working. And I hope as we move forward, if we have if there is a bill this upcoming session, that we can rely on you all to ask specific questions, if we can follow up with you directly, if that would be all right. And then I also wanted to thank Mr. Sanderson for the memo provided by MACo. It is incredibly comprehensive and answered a lot of questions that I had initially. So thank you very much for putting this together. Thank you all for being here today.
Thank you.
So we are getting close to our time, and I want to make sure that we have sufficient moment for public comment. But we have one last presentation today, and this issue, just for I guess for the record, there is a bill that Delegate Vitale has, and we offered her to come today to use this opportunity for a bill hearing. Unfortunately, she was unable to attend, and so we're going to focus less on the bill because we feel that it makes most sense that she be here as the bill sponsor. But we do want to kind of bring the issue to the attention of the committee and hear the particular case that brought up highlighted this potential issue. So, Mr. Jongarius?
Jongarius, yes.
Jongarius, okay. If you would like to go ahead, please.
Thank you, Chairman and members of the committee. My name is Jerry Jongarius, and I have firsthand courtroom experience with being denied copies, taking the agency to court, and the court said, sorry, case dismissed. There is no judicial review that is possible. So I appealed to the Court of Special Appeals, and they said that the circuit court did not err. So we have two problems with MPA. The first is State Government 10623 specifically does say whenever a person or governmental unit is denied inspection, there is no denial of copies mentioned. And Maryland's own Public Information Act manual calls this an oversight, which is pointed out to the court, but that didn't help at all. Technically, this should not matter. Every judge that knows Maryland rules knows that there is a rule for enforcing state laws where it's not expressly stated that you can enforce the law. Made no difference. In COSA, they even went so far as to say even if you had judicial review, 10620 does not apply to a denied copy. They cited Aristotle's potentiality, saying that a copy not made doesn't exist. Let me actually read what they said. Quote, a copy that has not yet been created and not material and has no form. Thus, an existing original or copy is a public record, while a copy that may be provided is not. So, like you said, Vitale's bill should address both of these issues. And I am here just to express to you that I've run into this, and my experience with the agency is that they used MPA as a weapon. Records that were digital, that I asked them to return to me in electronic form, they said, no, you have to pay the copy fee and get it on paper. So there are issues out there. This bill, I think, will address it very nicely, and I'm here to encourage that you look at the bill and provide feedback. Thank you.
Thank you very much. Any questions from the committee? If I may, what, and if you feel comfortable, what agency?
Frederick County Public Schools.
So it was a local. It was a local jurisdiction.
Yes.
Okay.
Local county agency.
Any questions?
Well, yeah, this falls into the category of me not being an attorney. So you have the right to inspect a document, but so can you pull, not that this would be at all practical, does that mean the ability to take out your smartphone and take a photograph of the document? Are you violating the law when you do that?
According to the Frederick County Public Schools, yes, that's a copy. PIA specifically says you may have a copy, a photograph, or what's the third? Reproduction. They specifically mention a photograph as a means to allow a copy. That's in the law right now.
Gotcha. Thank you. I'm done.
Thank you very much for bringing this issue to our attention. For the agencies in the room, I encourage you to speak with Delegate Vitale. This will be very likely a bill before the 2014 General Assembly session. So if you would like to preemptively offer your thoughts on this issue, I know Delegate Vitale is very interested in this issue, and she would like any feedback that the locals or state agencies may be able to provide. I guess the bill number, there was no bill last year, correct?
No, it's new.
There's currently an LR number or a draft of the legislation that I'm sure Delegate Vitale would, and I believe we left it.
There were some copies left out here, and I emailed a copy.
So there are copies available. So, but if you do have comments, it would be helpful if you'd send it to the Joint Committee as well so that we can see how the issue is sort of brewing. Before we go to the public testimony, I just want to make a note that we are working on an open data bill. Currently, when we think of transparency in government, there are the Public Information Act requests, there are the open meetings body of work, and then there is this looming and growing metadata, open data question. And so we are working on a bill draft for this upcoming session in coordination and conjunction with agencies that ideally will focus predominantly on the state level and how we can start sort of shifting towards a culture of open and collected data. This is a heavier lift than I imagined when first stepping into it, because as everyone probably in the room knows, there are lots of details and lots of potential unintended consequences that we want to be very mindful of. And the goal of the legislation is to be productive and collaborative, not something that is a forced approach. If you have thoughts, hopefully we'll have a public version of that bill available in early December for agencies for comment, and the more comments, the better. This is hopefully a collaborative process. So I wanted to give that note, sort of that public awareness notice at the moment. We have 3 individuals signed up for public comment. Jim Snyder I have not seen, so I do not believe he is here. Going once, twice, sold. Next is Seamus Craft with the Open Government Foundation. Seamus, did you just here for support?
Yes,
and
sir.
Excellent. And then Jennifer Bevan Dangle, I know you were here. Comment?
We'll be submitting written testimony. We don't have any verbal testimony this time.
Wonderful. Well, it seems that we have finished our business for the day. This was a very helpful session. I thank you all very much for your participation. Members of the committee, thank you for being here. We are all busy this time of year. We do not have another meeting scheduled at this point. Should there be the need as we move forward on this open data or Delegate Vitale's bill or any other legislative issues, we will make folks aware. We likely will have a meeting at the very beginning of session, however, to see where we are on some of these pieces of legislation and when we're all here in this lovely town. So thank you all, and have a wonderful week. The meeting is concluded.